Hi. In this month's blog, we're going a little informal in honor of March Madness. Go Green. And we're going to talk a little bit about sports and kids participating in sports and the concept of assumption of risk. I was recently contacted by a mom whose son was playing hockey at a relatively high level and was hit by an opposing player. And it was a type of hit that's illegal and was penalized, and in fact the opposing player was suspended. And the question around that case was, is this actionable? Can you bring a civil lawsuit? The answer is yes, you can, but these types of cases are very fact dependent. In that particular case, we encounter the concept in the law called assumption of risk, and that is pretty much a self-defining concept, and also it means that if you agree to participate in a sport and you are hurt and the injury comes about as a result of something that is reasonably anticipated by a reasonable participant, then that's not anything that is actionable, and those cases will probably be dismissed. It's a very case-by-case analysis, and since and it kind of gets there's obviously a line at some point where you are not assuming the risk of a certain type of hit. So from a hockey standpoint, I would say that if the other player had, for example, taken a swing with a hockey stick, that certainly in my mind crosses the line over what you would reasonably expect to see happen. In other words, the hockey stick is used throughout the game and certainly makes contact with players and can be penalized for that, but a two-hand axe-like slash to the head as you move further away from something that is a component or an expected part of the game, you move further away from the risk that you've assumed. These type of cases also have additional components that can be looked at if a sports participant is injured. And that includes coaching decisions, negligence in the setup of the sporting facilities or the event. We've had cases where gymnasts were injured because the mats were not placed properly at their meet and were done in a negligent manner and had a role in causing the injury to the gymnast who was participating and landed badly on those mats. And so another good example would be football. There's actually a law that began in Washington, the Lystat law, which indicates that if a football player has any possibility of being concussed, if they lose their helmet, they are automatically sent to the sidelines for a quick evaluation. If they suffer a good blow to the head, if they demonstrate any of the symptoms of a concussion, there had to be a law passed to say that the coach can't send them back in, because to do so would be inherently negligent, because closed head injuries, of course, have very serious consequences. So within the realm of sports injuries, especially with children, there's always a lot to be looked at. We have to look at outside forces, and then, of course, the specific facts of cases to see if there's an assumption of risk defense that would prevail. If you have any questions or concerns about an injury case that is generated from a sporting event, we're happy to talk with you about it. At Wiener and Lamka, our consultations are always free. And again, go Sparty.